My lord, I've concluded my argument. I'm just here to place the judgment before my lord.
Only for filing of.
And this is the
Yeah.
notes of argument, my lord. I've served the copy to my lord.
Okay.
No.
So, is your
When I'm going to start the civil matters, Your Lordship, some of the lawyers have kept the criminal books here. That's a whole, I'm about to solve. They are criminals. No. If I start my argument with saying that this matter has some checkered history, I would be right in my submission, Lord.
Yes, you are always ready.
Lord, why I would say, Lordship, this is a civil division challenging an order of the district judge. By virtue of which, Lordship, the district judge, being the first lower appellate court, affirmed the trial court's judgment, granting mandatory injunction during the pendency of the suit. So this mandatory injunction under section 37 of Specific Relief Act and the power to be exercised has to be done sparingly.
Yeah.
It's not like a temporary injunction. In a civil suit, a temporary injunction in the form of a prohibitory nature can be granted. Court normally does it mechanically based on affidavit, based on three golden principles of law. But when it comes to a mandatory injunction, because the clock would be put back to its original position. This is a fit case where the trial court could not have granted mandatory injunction pendency of this suit. I'll just take notice to the very tenor of the matter, and this matter travelled up to this court at the first instance. Then the matter was sent back to the district court. Then the order came to pass. I'll just show the trial court's order first. It's certificate.
Impugned order is order number 3.
Order number, yes, man. Order number
30th October.
Yes, of the district judge.
What is in this order?
Well, I'll just take it. This matter was moved at Calcutta, my lord. Just one second.
Temporary mandatory injunction
Hold
is considered and allowed.
Because when the matter was moved at Calcutta, my lordship, leave was sought for on 19th of November. On that day, the certificate copy was not made available because
Why this matter has been moved before the regular court?
the circuit
Vacation?
was not there.
Vacation
There was,
court.
yes, there was some extreme urgency, and the honorable court, by His Lordship Honorable Justice Raja Bashu Chaudhary,
Yes.
protected my interest till the last day of this circuit. Now, may I say one thing? The
Yes.
order of the district judge, because a leave was obtained and I was allowed to move the application. It's an order dated, not judgment dated 19 November 2024 of the district judge. Before that, I'll take most of the trial court judgment, order number 3, dated 30th of October 2024. I'm just placing this order. Then only, the matter can be placed in a proper way. What are the suit all about? When the suit was filed, dates are very crucial. Filing of the suit, frame of the suit, prayers made in the suit, and an injunction application filed. It was not pressed. Then mandatory injunction application came to be filed. Then the order was passed by the court below. I'm just placing order number 3, dated 30th 10 2024.
Order number 3, dated 30th. Yes.
Plaintiff moves a petition under section order 39, rule 1 and 2 of CPC, praying for temporary mandatory injunction against defendant.
Yes.
The gist of the plaintiff's case is that plaintiff was inducted as tenant with respect to one shop room being shop number 1 and the room existing on the backside of the other 3 shops in the first floor. Road level in the RCC building, standing survey number 26/34 situated at Gurdwara Line, Aberdeen village. The plaintiff was inducted as tenant on 26/11/2019 and a rent agreement was executed between the plaintiff and the defendant with respect to the shop room. In the said building in the basement, the defendant is residing along with his family members, and in the first floor of there are 4 shop rooms. Out of these 2 rooms, shop room number 2 and 3 have already been let out to other 2 tenants on a monthly rental basis. And one room being shop room number 4 is in occupation of the defendant, wherein the defendant is running money lending business under the name and style of Thiru Venkateshwara Finance. Plaintiff had taken the shop room number 1 and the room existing on the backside of the other 3 shops in the first floor, road level, on a monthly rent of rupees 12,000 per month. At the time of induction as tenant, the plaintiff had deposited a sum of rupees 13 lakhs as a security, and the defendant had acknowledged the receipt of the same. At the time of execution of rent agreement, it was mentioned that the tenancy commences from 1/11/2019 and will remain on operation for a period of 11 months up to September 20. The said rent agreement was duly notarized before the notary public. Once again, the rent agreement was executed from the month of October 2020 to September 2021. And once again, the agreement was extended in the month of August 2022 till the month of June 2023, and the rent was enhanced to rupees 15,500. And once again, the rent agreement was extended from 1/7/2023 till 31/5/2024, and the monthly rent was enhanced to rupees 16,300 per month. The plaintiff, herein with the consent of the defendant, had got her shop room registered before the Labour Commissioner under the Andaman Nicobar Island Shops Establishment Regulation, and the registration was extended time to time. The plaintiff is running the said shop room under the name and style Times Professional and Customs Tailoring. The plaintiff states that in order to develop the said house, said business, the plaintiff herein had obtained loan from Canara Bank for a sum of rupees 10 lakhs by hypothecation of stocks of the firm, and loan was sanctioned on 3/10/2020. The plaintiff has also got the establishment registered under the Ministry of Micro, Small and Medium Industry. The sanctioning of the loan, registration of establishment under the micro type were all done with the consent of landlord. After the expiry of the rent agreement, the plaintiff herein had approached the landlord defendant for extension of rent agreement, and the defendant told the plaintiff to wait for some time. On assurance of the defendant that he would be extending the agreement, the plaintiff had invested about 54 lakhs for purchasing stock, and the plaintiff had further invested rupees 34 lakhs for false ceiling, tiles work, plaster works, fixing of PVC panel, electrical, etc. For showrooms purpose. All the works for developing the said shop was done with the consent of defendant, and the defendant has demanded for further enhancement of rent, which the plaintiff had agreed. As the defendant in the middle of October 2024 started threatening the plaintiff to vacate the premises, to which the plaintiff had replied that it is not possible on a part to vacate the premises, and the plaintiff had made heavy investment in the said shop room, and as such it is not possible to vacate this said shop room. In clause 9 of the rent agreement, it was agreed between the plaintiff and the defendant that the tenant shall, at the termination of tenancy, unless it is renewed for further period by mutual consent, deliver possession of the said premises in good condition. And if the tenancy is renewed for further period, fresh agreement will be executed between parties, and the rent will be fixed as per the prevailing market rate. In clause 8 of the rent agreement, it was further agreed between the plaintiff and defendant that if the landlord wants the tenant to vacate the tenanted portions, the landlord shall give a minimum 1 month notice in writing to tenant. Similarly, if the tenant wants to vacate the said shop room of her own, she will give 1 month notice in writing to the landlord. Finding no other alternative, the plaintiff herein had sent a legal notice dated 23/10/2024 by speed post to the defendant on 24/10/2024, calling upon the defendant to come forward for extension of the rent agreement and not to harass the plaintiff. The plaintiff has done investment in lakhs of rupees, and as such, it is not possible for the part of plaintiff to leave the premises all of a sudden. On 25/10/2024, midnight, the defendant with his men and agents had broken the lock of shop room and had thrown the sewing machine, table and clothes belonging to the customers, and also the dress materials which were stocked by plaintiff for her business purpose. On 26/10/2024, the plaintiff herein was informed by one auto driver that the articles of shops room are lying outside, and upon hearing this, the plaintiff immediately rushed to the spot, and plaintiff found that the major stocks of the shop room was lying outside and a new lock was put in shop room. Upon seeing the condition of a stock, the plaintiff was in utter shock, and thereafter the plaintiff has informed her relatives, who all came to the spots, and the plaintiff thereafter went to the police station Aberdeen. And the defendant herein was called in the police station, and the defendant agreed that the defendant had opened the lock and removed the articles from the shop room. That the plaintiff states that plaintiff thereafter made a written complaint in police station and FIR under section 324(4) and 331(4) of Bharati Nyaya Samhita 2024 was chalked out against the defendant. After returning from police station, the plaintiff herein went back to the shop room, and plaintiff was not allowed to open the shop lock of the plaintiff, wanted to see the cash and other valuable kept inside the shop, but the defendant stopped the plaintiff from opening the shop. On 26/10/2024, the defendant and his family members has assaulted the plaintiff, and the plaintiff had reported the matter to police station, but no action was taken against the defendant. And once again, on 27/10/2024, at 5:30 p.m., the defendant and his family members has assaulted the plaintiff, and the plaintiff has sustained injuries on her person. And the plaintiff was treated as an outpatient at G1 Hospital, Port Blair. The plaintiff had again reported the matter to police station Aberdeen, and FIR number so was chalked out against the defendant and his daughter and grandson. The plaintiff has been suffering very badly due to such conduct of the defendant, who had illegally and without any authority entered into the shop room, damaged the shop of plaintiff. The plaintiff has been put to several financial loss by the defendant, as the stocks and other valuable items are still lying inside the shop room. Many of the customers who had given their dress for stitching are continuously demanding their dress, and the plaintiff is unable to get the same, as the defendant had put the lock in his shop room and have thrown partial dress material outside the shop, and other stocks is lying inside the shop. The plaintiff has got air-conditioned CCTV installed in the shop room, and the plaintiff apprehends that due to the damage of the stocks by the defendants, there may be further loss to the plaintiff, as the defendant might be damaged the CCTV also. The cause of action of filing this application arose firstly when the tenancy was created, and secondly on 23/10/2024 when the plaintiff has sent legal notice to the defendant, and thirdly on 25/10/2024 when the defendant had forcibly broken the lock of the shop room and thrown the articles of shop room and put the padlock. And cause of action continued as the plaintiff is not allowed to enter into the shop room despite approaching the police authorities. The plaintiff did not get any remedy, and the plaintiff was advised by the police to approach the civil court. Plaintiff has prayed for temporary order of mandatory injunction directing the defendant to open the lock and allow the plaintiff to enter into the shop room for conducting her business forthwith till disposal of prevent application. Plaintiff has filed photostat copy of Google Pay transaction, photocopy of rent agreements, photocopy of FIRs, etc. in support of claim. Defendants has filed written objection stating that plaintiff is defaulter in paying rent, and the plaintiff used the said premises other than for the purpose for which it was let out, and the defendant denied to have received rupees 13 lakhs as security. The further contention of the defendant is that since the period of tenancy lapsed by flex of time, and none of the clause, including the clause 8 thereof tenancy agreement, is operating as if now in between the plaintiff herein and defendant, and in that view of the matter, there is no lawful tenancy subsisting in between plaintiff and defendant in connection with tenanted premises. Plaintiff has voluntarily handed over the actual physical possession of tenanted premises to the defendant on 25/10/2024, and thereafter oblique motive prevailed, which would be evident from the very fact that the plaintiff, having filed criminal complaints against the defendant and his family member one after other before the police station in order to put pressure upon the defendant to redeliver possession of tenanted premises. Each and every family members of defendants were dragged to police station by the plaintiff in order to succeed in her nefarious and ill motive of the plaintiff. Even the injunction order as stated in the injunction is granted, then and in such event, the plaintiff would, taking shield and order of the mandatory injunction, would forcibly take possession of the tenanted premises from the defendant. The plaintiff is not having the actual physical possession and the occupation of tenanted premises. Rather, the actual physical possession and occupation of tenanted premises is with and under the defendant, and as such, no order in any form can be granted in favor of plaintiff. In order to harass the defendant and his entire family members, false complaints have been lodged before the police station Aberdeen, who for some extraneous consideration acted on the basis of false complaint of plaintiff without even making preliminary inquiry as per law. The complaint of defendant as against her for committing unlawful act was reported to police station, but no action has been taken. There is no, let alone strong prima facie case in favor of plaintiff to enjoy mandatory injunction order as claimed in the purported application dated 29/10/2024 filed by the plaintiff. There is no urgency looming in favor of plaintiff to enjoy an order of injunction any mandatory form. Balance of convenience and inconvenience tilt in favor of defendant and not in favor of plaintiff as alleged demonstrated. Defendant would suffer in the event the injunction order in the mandatory form as claimed by the plaintiff is granted. The mandatory injunction application dated 29/10/2024 is not maintainable in the eye of law as the same is liable to be dismissed. There is no strong case for trial which warrant mandatory injunction in favor of plaintiff at this juncture. The plaintiff, even if succeeds ultimately in suit, reference to claim which could be tested with the touchstone of credible proposed evidence of the plaintiff. Then and in such case, she can compensate her in terms of money since her possession over the tenant premise was beyond the period of tenancy and that she of her own voluntarily handed over occupation and possession of tenanted premises to defendant herein, and such conduct on her part upon is hit under the doctrine of waiver and acquiescence. There is no extraordinary and special situation and circumstance made out by plaintiff in the present suit for enjoyment of injunction order in mandatory form. The relief as sought in the suit is beyond the purview of consideration by this honorable court, being without any basis, and the order in the form of mandatory injunction would literally amount to deciding the issues in the suit during pre-trial stage, which deprecated under law. The relief as claimed and labeled under the mandatory injunction application dated 29/10/2024 stands no merit, and the application is liable to be rejected. Peruse the case record and consider the submission of both the parties. On perusal of the rent agreement dated 26/11/2019, it appears that there is a clause that a tenant has deposited 13 lakhs as advance to the landlord, that is defendant, and the agreement was signed by both parties. So the defendant has denied to have accepted 13 lakhs as security from the plaintiff. Plaintiff has filed some money receipt showing payment of money amount of rupees 16,300 per month to defendant by UPI transaction up to month of July 2024. Though the contention of the defendant is that the plaintiff was not paying rents, it appears that mandatory injunction can be granted in interlocutory stage, but it is a remedy which should not be granted easily. Rather, only in the circumstances where the prima facie material clearly justify a finding that the position would be altered by one of the parties to the litigants, and the interest of the justice demands that the position should not be restored. The Honorable Supreme Court in Dorab Kawasi Warden versus Komi Sarab Warden and others 1992 SCC 117 held that the relief of interlocutory mandatory injunction are thus granted generally to preserve or restore the status quo of the last non-contested status which preceded the pendency controversy until the final hearing, when full relief may be granted, or to compel the undoing of those acts that have been illegally done or restoration of that which was wrongfully taken from the party complaining. But since the granting of such an injunction to a party who fails or who fails to establish his right at the trial may cause great injustice or irreparable harm to the party against whom it was granted, or alternatively not granting of it to a party who would succeed or would succeed equally cause great injustice or irreparable harm, court have evolved certain guidelines. Generally stated, these guidelines are: the plaintiff has a strong case for trial, that is, it shall be higher standard than a prima facie case that is normally required for a private injunction. It is necessary to prevent irreparable or serious injury which normally court cannot compensate in terms of money. The balance of convenience is in favor of one who seeks such relief. The Honorable Supreme Court further went on to say that being essentially an equitable relief for grant of refusal of an interlocutory mandatory injunction shall ultimately rest in sound judicial discretion of court to be exercised in the light of facts and circumstances of each case. So the above guidelines are neither exhaustive nor complete or absolute rule, and there may be exceptional circumstances needing action. Applying them as prerequisites for grant or refusal of such injunction would be sound excess of judicial discretion. Therefore, it can be seen that Honorable Supreme Court has today, Dorab Kawasi Warden judgment, observed that the grant of interim mandatory injunction is not prohibited and that it can be granted only in appropriate cases. Further, the Honorable Supreme Court, while dealing with the contention raised in appeal in Hamad Ahmed versus Abdul Majid and others, 2019-14 SCC 1 is of the view that an application under Order 39, Rule 1 and 2, the court shall not grant interim mandatory relief resulting in creation of an entirely new state of affairs, which hitherto never existed. In the instant case, it is admitted by both parties that plaintiff was a tenant under the defendant. And as per the defendant, on 25-10-2024, plaintiff voluntarily surrendered the tenanted premises to defendant. But the contention of the plaintiff is that some articles and belongings of her shop was thrown out by the defendant while she was not in shop, and plaintiff's AC machine and some other articles belonging to her customers are still lying in the locked shop room, which was locked by the defendant. Defendant contention is that the plaintiff is a defaulter in paying rent, but I find no legal action has been taken by the defendant to recover the arrears of rent. It is also very absurd that the plaintiff would surrender the tenant premises in his own volition, and defendant would not keep any written record or surrender certificate from the plaintiff while he was surrendering her tenancy right. Prima facie, it appears that the claim of plaintiff is justified, and the articles of the customers of plaintiff and the sum of her belongings are still lying inside the tenant premises, which is locked by the defendant, and the defendant cannot evict a tenant by unlawful means taking law in his own hand. And to my considered view, the instant case is one which fall within the ambit of rarest of rare case, where mandatory injunction should be granted at the interlocutory stage to restore the earlier position, as plaintiff has a strong prima facie case and she should suffer serious injury which cannot be compensated in terms of money, and balance of convenience and inconvenience highly tilts in favor of plaintiff. Hence, it is ordered that the prayer for temporary mandatory injunction is considered allowed. Defendant is directed to open the lock of the suit property immediately and to allow plaintiff to enter into her shop to conduct her day-to-day business till disposal of suit. So this order was passed by the trial court. The sum and substance of this revision application is this order which has been challenged. My lord, I'll just show few things before I take Manoj to the grounds of attack, so far as these orders are concerned and the order of the first appellate courts are concerned. So the suit was filed on 28-10-2024.
Yes.
The suit filed, I'm the defendant here. Now, so the revisionist here is the defendant. 28-10-2024.
Suit filed.
You know, I'll just show the plain, just a glance. The nature, the frame of the suit needs to be seen. I'll show that. In such suit, this application could not have been entertained, and in such suit, no order could have been passed in the mandatory form. You know, kindly turns to page 14.
Yes. Suit for.
It's a suit for protection against illegal eviction and permanent injunction. I'll just take Milords to the prayer portion of the plain at page 19. Page 19. Page.
You are dependent tenant.
Defendant landlord.
Landlord.
Defendant landlord.
Oh.
This is what the plaintiff has asserted in the plain. I'll argue on that also. Now, kindly turns to page 19.
Yes.
Your Honor, I'll just take Milords to two prayers. Prayer A and B. A decree for protection against illegal eviction by defendant with respect to the shop room number 1 and shop room existing on the backside of the other three shops in the first floor of RCC building standing in survey number 26/34 situated at Aberdeen village. A decree of permanent injunction restraining the defendant from disturbing the possession of plaintiff or the suit land. Now, these sort of reliefs can only be maintained by a person who maintains the actual possession of the premises, because the nature of relief as claimed by the opposite party herein in the pending suit is that she is in possession, kindly protect my possession, and I should not be thrown out from the suit land without due process of law, and kindly grant me a degree of permanent injunction. The sine qua non in such a suit is that she has maintained the possession the day when she filed the suit. The suit was filed on 28-10-2024. Now, there was a clever approach made by the plaintiff. I'll show that. Along with this claim, at the first instance, the plaintiff takes out an injunction application. Now, kindly see at page 36, Order 39, Rule 1 and 2 application. 36. Temporary injunction application. Page 36 is the first page of the injunction, and prayer portion is at page 41. I'll just show the prayers, Marshal, which are relevant for the purpose of the adjudication. Lord would see the prayer at page 41. Same date, when the plaint was filed 28/10/2024, this application was taken in aid to plaint suit. It is therefore humbly prayed that the Honor may be pleased to pass an interim order directing defendant not to create any third party interest in the shed shop room and pass an order of injunction restraining defendant from creating third suit. The plaintiff asserted that I am in possession. The Order 39 rule injunction application would say that possession is with the defendant, landlord. Kindly restrain the defendant not to create a third party. So this injunction application was very cleverly not pressed. And why it was not pressed, I pleaded in my application, I'll argue, Lordship. What happens then, I have used my written objection as against the injunction application that on 28/10. My written objection, my Lord would see at page 44, it says against the injunction application under Order 39, Rule 1 and 2. And I clearly pleaded that on 25/10/2024, that's the date being prior to filing of the suit, the tenancy was surrendered by the plaintiff to the defendant. Because the tenancy period was not extended. It was for the period till May 2024, not sure. The tenancy agreement, time to time, which was extended, lapsed in the month of May 2024. There was some deliberation between both. Ultimately, my Lord, on 25/10/2024, tenancy was surrendered. Possession was given to me.
Is there any document in this regard?
Lord, there can't be any document. Lord, this was the trial court said. Lord, there cannot be any document in this island. For inducting a tenant, agreement exists. For surrendering it, there are several factors. Because if a tenant surrenders the tenancy to a landlord, off the record, money transaction are being done. This is also the same. Certain amounts were asked for my client agreed. He surrendered the tenancy. Everything was off the record, my Lord. I have clearly said 25/10/2024, you have surrendered tenancy. Then, my Lord, again on the following day, that's on 29/10/2024, the mandatory injunction application was filed at page 51. The dates are very crucial, and the filing date of suit is also crucial because everything occurred. Tenancy surrendered. I have taken possession. It's all done prior to the filing of the suit. Page 51.
Yes.
It's an application for grant of mandatory injunction, in which the order which I have read just now has been passed. But kindly see paragraph 50, page 56. The prayers, they are given a new color. Prayer A and B were added from the existing injunction application which was not pressed. Then the trial court considered the material and passed mandatory injunction. I have used written objection also as against this, which my Lord would find at page 60. My Lord, I could have understand the mandatory injunction is nothing but to put status quo ante. To ascertain this part, there should have been a status quo order as regard possession. The judgments which I would be relying in this present proceeding, all of the Supreme Court says in all these matters, there was a civil dispute, there was a prohibitory injunction order in the form of a status quo with regard possession. And if any party who is suffering such order, if possession is disturbed, who secured the order, then in such a case, mandatory injunction can be granted. Not in the present suit, there was no order of status quo. And the suit was filed on 28/10, but everything was done on 25/10/2024. Not leaving aside these aspects also, not whether the tenancy was surrendered and whether the very suit, not the frame of the suit may kindly be seen. Suit, not interlocutory applications.
When tenancy was surrendered?
on 25/10/2024.
25.
10/2024.
2024.
Suit was, I'll just have given the date. Suit was filed on 28/10.
After surrendering of.
Yes, Lord, we are human beings. We are guided by our brains. Lord, evil motive prevailed. When the plaintiff handed over the possession, she immediately approached to the police station. She lodged 2 complaints back to back against my client. It's pending, one for molestation, just to put pressure upon me, and immediately suit was filed. Now, this order of mandatory injunction of the Civil Judge Senior Division was at the first instance straight away challenged before this court. I'll show that also. That's not required to be shown.
Yes, one CEO was there.
Yes. His Lordship Honorable Justice Rajshekhar Mantha had an occasion to deal with it. I'll show those 2 orders. Lord would find
One CEO.
page 81. Page 81. You know, if I read this order, well, not everything would be clear. The proposition of law with the taxon of facts as stated. I'll show this order, 81. Now, you see, same order of the trial court. The revision application is directed against an order number 3 dated 30th October 2024, passed in other suit number 82 of 2024 by the Civil Judge Senior Division Court.
Same order has been challenged there.
Challenge. Then thereafter, the other side have raised a point of maintainability that the order is not is an appealable order. Then this Lordship said you approach before the appellate court. Then I approached the appellate court. The order was passed. Now this is division. But why I am showing this order?
So final order was passed there.
No. I'm coming to kindly see the 81 once. I'm just showing 81. Lord, kindly see 81.
Yes.
81 Lord kindly comes to Lord kindly see. 81, 82 may kindly be seen. I'm just placing right from paragraph 6. The suit was therefore an afterthought, and the possession of the revisionist, I was the revisionist landlord in the shop room, is confirmed by the application for injunction filed on 29/10/2024. The revisionist filed his objection stating that he was in possession of shop room. The court below by the impugned order directed the revisionist to open the lock of shop room and permit the plaintiff to enter into the premises. This court notices that the plaintiff has been reprobating the court below. The impugned order has an effect of allowing a final degree of possession to be passed at an ad interim stage of an interlocutory proceeding. The circumstances under which a temporary injunction may be granted in aid to a mandatory injunction has been enumerated in the decision of Dora Verma Koshi Warden versus Komi Saran Warden, reported in 1992 SEC. This is not one of such cases. The facts of the instant case did not attract the principle laid down in the aforesaid reason. In these circumstances, let all further proceeding in other suit number shall remain state for a period of 6 weeks from date. The impugned order also state. Then immediately on the following day at page 84, the matter was mentioned before his lordship, and the point was raised. The order which has assailed before the High Court is an appealable order under Order 43 Rule 1. Then lordship, the Honorable Court granted me a liberty to question this order before an appropriate appeal. Lord, kindly see 84, and I'll show 85.
Then why this revision?
And then the district court was approached.
If the order is applicable in nature.
No, I have approached the appellate court. Appellate court dismissed my appeal.
Where is the order?
No, it's there because server copy is there. Not would find.
Then after dismissal of your appeal.
Yes, I have come up.
Again, revision may lie.
Yes.
If revision meant
Civil.
Either revision lie or not.
No. I approached the district court.
Yeah.
District court in my appeal, misappeal, dismissed the appeal, thereby affirmed the order of the trial court. Now the only remedy left to challenge both the order of the trial court as well as the first appellate court is before this court in the present proceeding, civil division. Civil division under Article 227, my lord, read with 115 of CPC. Not page 85.
You are challenging here order number 3.
Yes.
Dated 30th October 2020.
Yes.
Which is appealable order?
Appealable order is the judgment dated 19th November 2022, which was affirming the order of the trial court, which I've shown, which I've read.
Where is?
It's there,
this
Lordship,
is-
it was a server copy, Lordship, it was filed. Leave was obtained on 19th before Justice Raja Basu Chaudhary. Leave was granted. It was moved as unlisted matter. Rather, it was upon notice the matter was other side appeared also. My Lord would kindly have a look to the order passed by this court at Calcutta in the present matter dated 7th November 2024. 7th November 2024. No, it's not 7th November. Just
21st November.
Yes, yes, Amar.
Justice Raja.
Raja Basu Chaudhary. Yes, you kindly have a look to that. Yes, I'm grateful.
Challenging the order dated 19th October 2020. Where is the order dated 19th
It's
October?
there in the application. Hi, it's there. 19 November. Before the trial court's judgment order, Lordship.
19th November.
November, yes, of the district judge. This appeal was filed after the leave was granted by His Lordship Honorable Justice Rajshekar Manta.
And what is your prayer now?
My point of argument is, in the present suit, the mandatory injunction cannot be granted. That would amount to deciding the main issue in this suit in an interlocutory stage. That's my first point.
It's a contract.
But this was not a fit case where the mandatory injunction can be granted. I could have understand. I'm also a lawyer practicing purely in the civil side in this island. I can understand. Had there been a status quo order, status quo as regard nature, status quo as regard possession, and during the subsistence of such order, if any party flouts the order, then a case of mandatory injunction can be made out. But here there was no status quo order. The trial court
At final stage.
absolutely not. The trial court lordship has literally allowed the plaintiff to take possession of the suit premises, which can't be done in this during this stage. These are the matter to be gone into in a suit, not evidence need to be thrashed out. Whether she has voluntarily surrendered the tenancy or whether had taken forcefully, and particularly not the frame of the suit may kindly be seen. Their suit is all about a decree of permanent injunction. That means she is in possession, and her conduct of filing an injunction application under Order 39 Rule 1 and 2, seeking a restraint order
Permanent injunction
against my client, not to interfere with her possession.
So, plaintiff is not in possession.
Absolutely.
He has handed
Absolutely.
over the possession to
Absolutely.
you.
This decree can't be granted. In a suit, such decree can't be granted. How in an interlocutory stage, mandatory order can be granted? So the order of the trial court allowing her to take back the possession would amounts to giving a final decree. This can't be done. Absolutely not sure. That is the cash lordship. That is what I want.
After handing over the tenancy, how an order can be passed to get
Absolutely not. I'm grateful. I'm
get
grateful.
back the possession of
I'm
the
grateful. I'm grateful. No, that's what I'm saying, lordship. It can be done. It can be done provided there is a status quo order operating in the field. Status quo.
No status quo.
No status quo. In the present case, there is no status quo. Simply status suit for permanent injunction was filed. Order 39 was not pressed. Mandatory injunction came to be passed. Order was passed. You know, the very order of the trial court negates the very plain case. The very order of the trial court, because the trial court now has said, my client, you put plaintiff back into possession. If that is done, then the very suit, because this is nothing but you are not giving a decree in the interlocutory stage, because suit is a decree of permanent injunction based on her alleged possession. And not entire episode. No, let's go with the worst situation. Let's go with the worst situation. I don't admit it for the sake of argument. I have, without any due process of law, taken the possession also. Now, these things have happened when? Before filing of the suit. The only remedy is Section 6 of Specific Leave Act. If a person is dispossessed within a period of 6 months, one can seek for restoration of possession. The suit is not maintainable. If the suit is not maintainable, no interlocutory application in any form can be granted. It's not my duty to advise the other side, but that is only remedy available. Because their case is on 25/10/2024 in the midnight, I have used goons, I have used my force to evict her out. Then the suit could have been a suit for restoration of possession under section specific, and that too within 6 months. But that was not a suit all about.
What about the criminal cases?
No, it's still pending. It's still pending. No, I'll just take 2 more times and then I'll place 2 judgments, relevant judgments. I will not kill the time of the court.
Yeah,
So, my lord.
because we are running short.
Sure, absolutely. So my point of argument, lordship, just to buttress my argument, I would rely the same judgment. It's a celebrated judgment on the issue. This Dora Kausi Garden case.
Yes.
I'll just place that judgment. No, just. It's reported in 1990, Volume 2, SCC Supreme Court Cases 117, Dora Kawasiji Warden versus Homi Saurabh Warden and others. Not in this case, as I've argued just now, there was a status quo order operating in the field. And during the subsistence of status quo order, the party who was suffering removed from the premises. Then the court heavily held in such a case, mandatory injunction can be granted, possession can be, status quo ante can be put back. But the guidelines have been laid down. Lordship, it's an authority on this point, Lord. I'll just show that paragraph. Because in an application under Order 39, Rule 1 and 2, not most, if I file an ad interim protection, the day when the suit is filed, the court based on the document on affidavit casually and mechanically grants it. Status quo, you just maintain status quo, or both the parties need to maintain status quo. When the application is contested, then those 3 golden principles will come into effect. Balance of convenience, irreparable loss in any prima facie case. But in a mandatory injunction, my lord, the standard and the satisfaction of the court is beyond the Order 39, Rule 1 and 2. It's not in a casual manner it can be taken. A mandatory injunction application plain granted, no, it can't be done. Well, I would beseech my lord to come paragraph 16. I'm just placing the judgment, not just read out and place it. The relief of interlocutory mandatory injunction are thus granted generally to preserve or restore the status quo of the last non-contested status which preceded the pending controversy until the final hearing, when full relief may be granted or compel the undoing of those acts have been illegally done, or the restoration of that which was wrongfully taken from the party complaining. But since the granting of such an application to a party who fails or who would fail to establish his right at trial may cause great injustice or irreparable harm to the party against whom it is granted, or alternatively not granted of it to a party who succeeds or would succeed may equally cause great hardship or irreparable harm. Court have evolved certain guidelines. Generally stated, these guidelines are: number 1, the plaintiff has a strong case for trial. That is, it shall be of higher standard than a prima facie case. Simplicity prima facie case will not do. The requirement of satisfaction by a trial court while granting mandatory injunction is beyond this purview. But kindly consider this judgment. Here, the Supreme Court said mandatory can be granted because there was status quo. Now, there is one more judgment I have brought.
Paragraph 16. Paragraph 16.
Paragraph 16. That's right. Now, this is the case of Metro Marine. Metro Marine and others versus Bonus Watch Company Private Limited and others. It's paragraph 9, my lord.
Yes.
Paragraph 9. So this judgment may need to be considered. But there is one judgment of our High Court by Justice Vivek Chaudhary. Lord, this is in CO number 359 of 2017, where the Honorable Court said mandatory can be granted. but the facts was distinguishable. In that case, after the suit being filed, all lordship starts from the point of filing of the suit. After the suit is filed, if a party is dispossessed without due process of law, mandatory injunction granted. But in the present case, everything was done prior to filing of the suit. There was no status quo order operating in the field. Lord, kindly consider this judgment because they may take shield of this judgment also. Lord, I would say, Lord, kindly appreciate one thing, Lord. I would humbly say the suit can be expedited, Lord. The trial can be expedited. The gray line of the dispute, Lordship, is this only. Whether the tenancy was a surrender of tenancy was a voluntarily given,
Yes.
or I had taken possession forcefully before filing of the suit.
Whether tenancy was with plaintiff or not,
Absolutely, Lordship.
voluntary surrender or by the act of law,
Hardly matters. Hardly matters.
is not matter.
Hardly matters. Hardly matters.
So, whether
Last argument, Lord, the tenancy which was extended lastly expired in the month of May 2024. Lord.
and after that,
No renewal was made. No renewal.
no. Did you accept rent?
No.
Yes.
No.
from me?
No.
Yes.
Those documents upon which the trial court has relied, Lord, kindly have a look to that. It was never accepted. Let's go with the situation what the other side is saying also correct. Lord, that is for the month of July
No,
2024.
I am not hearing other side right.
No, I'm just no, this is Madam may
At
argue-
present, you are before
Madam may
me
argue on
and
this
I
line.
am hearing.
Madam may argue on this line that
Yeah.
she would say that July 2024 it was paid. Even if that be taken is on account, which I am denying it, everything started in the month of October 2024. Lordship. August, September, October, nothing paid, nothing.
May. Expired in the month of
May 2024.
24. And you had accepted rent of June, July.
No, I have not accepted.
Not.
I have not accepted. It's my total denial. I have not accepted, not even a single penny. Well, I'll just read this section 39 of Specific Relief Act, where the mandatory injunction can be granted. Just 5-line section.
Yes. Yeah. Yeah,
Specific Relief Act section
specific relief
39.
act. Specific relief act के boy दिन खूब पतला हो गए.
Well, I'm just giving my book, Lordship. I'm just giving it. It's up to you. The 39.
Yeah, section 39.
39.
Mandatory.
When to prevent the breach of an obligation, it is necessary to compel the performance of certain acts which the court is capable of enforcing. The court may in its discretion grant an injunction to prevent the breach complained of and also to compel the performance of the requisite acts. Because the opening sentence of section 39 is there has to be some obligation. In the month of October 2024, there was no obligation subsisting in between the parties. If there is no obligation, be it in express, be in an implication, there hardly matters not that there is a violation of any obligation, which warrants the trial court to exercise the power to grant mandatory injunction under section 39.
Yes.
I would conclude with this, Lordship. I would pray, Lordship, the order of the first appellate court affirming the trial court's order of mandatory injunction, both the order needs to be reversed, Lordship. Lordship, let the suit can take its logical conclusion. At best, Lordship, the suit can be directed to be taken up day-to-day hearing if there is so looming urgency exists. But the order should not be allowed to remain in papers, Lordship. The order is unknown to law. It's against the transgression of the settled proposition of law. I pray for allowing the present application. That's all.
Yes.
Lordship, I would start to say first that if such high-handedness of landlord is protected and not interfered with, then hereafter every landlord will do the same thing with the tenant. There will be no rule of law here.
Yes.
Now, the sequence of story which has been narrated by the other side is completely different. Your Lordship, it happens, I have all documents on records, and that has been noted by both the courts.
Yes.
Now, Your Lordship knows the limitation in civil revision. Material irregularity and illegality. These are the only two things, and out of jurisdiction. And so far as the views of the trial court and the first appellate court are concerned, which is based upon the materials on record, can those views be negated by this in the revision? In my opinion, Your Lordship, it cannot be done. The decision is there of the Honorable Supreme Court rendered in 1965, first decision, where it has been held that the revisional court or the court's power under 227, even the view of both the courts, concurrent findings are there. Those findings have to be interfered with in order to believe the version of the other side. There are two things. One is that what are the facts, and prima facie what is to be believed and what order should be passed.
Yes.
Second part is that mandatory injunction cannot be granted. These are the two parts. Coming to the facts, 23rd October 2024, I issued a legal notice because I anticipated that the other side is going to evict me forcibly.
In what capacity?
Being a tenant, because we are governed by rent control.
As per the version of.
We are governed by rent control regulation,
Yes.
not by TP Act,
Hmm.
where time period is important. Rent control regulation 1964 prevailing in Andaman Nicobar Island says that a tenant can be evicted on certain grounds. In those grounds, completion of time period mentioned in the rent agreement is not a ground at all, which is there under the TP Act 106. So that is the difference. Otherwise, if I'm placing the rent control regulation, it says notwithstanding any contract prevailing in the field. Starts with that non-obstantive clause. Page regulation 13. Notwithstanding anything to the contrary contained in any other law or any contract, no tenant of any premises shall be liable to be evicted therefrom, except by an order of the court on any one or more of the following grounds. Now, first ground, the tenant has neither paid nor tendered the whole of the arrears of rent legally recoverable from him within 1 month of the date on which a notice of demand for the arrears of the rent has been served on him by the landlord in the manner provided in section 106 of TP Act 1882. That the tenant has, without obtaining the consent in writing of the landlord, sublet the premises or use the premises for a purpose other than that for which they were let. That the landlord requires the premises bona fide for occupation as residence for himself or any member of his family, carrying out repairs, alteration, addition to the premises, and such repairs, alteration, addition cannot be made without the premises being vacated. That the premises were let for use as residence and neither the tenant nor any member of his family has been residing therein for a period of 6 months immediately before the date of institution of any proceeding for eviction. That the tenant has, whether before or after the commencement of this regulation, built, acquired, a vacant possession of or been allotted or suitable residence. That the premises were let to the tenant for use as a residence by reason of his being in service or employment of the landlord, and that the tenant has ceased, whether or before or after commencement of this regulation, to be in such service or employment, or the tenant has, whether before or after the commencement of this regulation, caused or permitted to be caused substantial damage to the premises, nor with notwithstanding previous notice, has used or dealt with the premises in a manner contrary to any condition imposed on landlord by the government while giving him a lease of the land on which the premises are situated. So it clearly says the grounds.
Yes.
Now,
Where is the regulation?
this is the regulation.
Whether tenants in Andaman are guided by this?
Yes, Andaman and Nicobar Rent Control Regulation 1964, which has, there are certain amendments the government is saying has been made, but it has not been,
It's of
They-
1964.
yes. Even today, this is only prevailing because the new one has not been come into force.
You referred
Clause,
regulation number?
Regulation 13.
अच्छे मैंने एक रेगुलेशन का है इसके अंदर में ये तो आर्टिकल ऑफ एसोसिएशन ये क्या है रेगुलेशन 94. Yes. So you filed a photostat copy of this.
Yes, I will provide.
Like this only. Yes. So
And this,
there are certain grounds
yes,
stated in regulation 13.
yes. And none of the grounds says that if the time period is has expired, the tenancy will go away. If that is so, the rent control regulation, those grounds are meaningless.
Hmm.
Because under the TP Act, that provision is there.
Yes.
Now, up to July 2024, rent was accepted, which has been mentioned in the order of the Honorable District Judge.
Thereafter.
Thereafter, dispute started. Dispute
Then
started, he
in case of
refused.
dispute.
Yes.
Where the rent are submitted before rent controller or
No, here we don't have. They don't have that facility. It is only in a case when an eviction suit is filed under Regulation 14, I can deposit the rent.
where?
Before the court. When eviction suit is filed before the civil court, I can deposit the rent. That is the only way. Kindly see Regulation 14. If I file a suit for protection against illegal eviction, I won't be permitted to deposit the rent. I can be permitted only in a case where eviction suit is filed by the other side. Under Regulation 14. Judgments are there in that line. Even this honorable court has dealt with that issue.
So district court
Yes.
held that
July up to
rent up to June or July.
6th July 2024, payment was made.
Of of the June.
Huh,
You
it will be
paid
June
rent.
only, yes. June payment was made in July 2020.
Rent up to June has been paid.
Now, Your Lordship, if the intention of the other side was that in May the rental, as per the rent agreement, the time has expired, then
Yes.
immediate action, Your Lordship knows this is by GPay it was made, Google Pay. He would have reverted back. Very simple thing. If that intention was that the tenancy expired, why is paying the rent? Revert it back. Did he do anything of that kind? No, because there was no problem with, up to that time, there was no problem. It all started from August. There was deliberation. Both of them were speaking with regard to the extension of tenancy, new agreement and all those things, rent, everything. All these things were, both of them were conversing with each other. Now, problem started.
But after June
Yes.
and before August, there was no agreement, no extension.
Agreement is not there. Agreement after no
Extension of-
extension. No documentary evidence is there. On oral, this thing, it was getting extended. My only point is that even assuming for argument's sake, there is no extension.
Yeah.
Can I be evicted forcibly from the premises? If that is the law, I am nowhere. If that is the law. Because conduct of the parties have to be looked into. You are accepting the rent in July 2024. That means you yourself is not accepting that May 2024 the tenancy expired, because July June rent you have accepted. Now, when the problem started, this is very important, Your Lordship. I issued a legal notice on 23rd October 2024, because we have to see the sequence. 23rd October 2024 legal notice has been issued. That has not been
23rd October.
Yes, that is not enclosed here, but it was there with the learned code below, and it is mentioned in both the orders. 23rd October 2024.
Yeah.
Now, 25th October 2024 night, the landlord entered, took some part of the materials which were lying inside the shop, placed it in front of the shop, locked it, and went away. This happened on 25th October night. Because it's a shop, nobody resides there. Now,
So break open the lock.
yes, 26, no, he locked it.
Who
26,
locked it?
landlord.
Landlord.
Yes, landlord entered, took some material, put it outside the shop, and locked it, and went off.
How he managed to open the lock?
Breaking it. By breaking
Key.
the lock. He broke the lock and then put his own lock.
Yes.
As it happened on 25th October. Now, Your Lordship, we kindly see the page number 22. Your Lordship, may kindly come to page number 22. 151 million. Page number 22. Because sequence are based upon documents. Connection has to be seen. Now, if I am able to satisfy that on the basis of these documents, I am able to prima facie satisfy this honorable court that this is a case of forcible eviction, am I not entitled to any mandatory injunction? I have judgments. Up to that point, same thing happened. And the facts are so similar, Your Lordship would be surprised at how the facts will be so similar. The tenant was removed forcibly. Landlord is approaching the court, and Your Lordship, it has been said by the other side that when I filed the suit, I did not mention anything about this particular incident. And subsequently only, I not pressed the injunction application and filed an application for mandatory injunction. Absolutely incorrect submission. I will show from the suit itself that I have stated these facts in the suit itself. Kindly come to paragraph . Page number 17, paragraph 23. Because it was projected to this honorable court that this is an afterthought. It was not an afterthought. It was there since the beginning.
Paragraph
23.
20.
That the plaintiff states that on 25/10/2024 midnight, the defendant with his men and agents had broken the lock of the shop room and had thrown the swing machine, table and clothes belonging to the customer and also dress materials which were stocked by the plaintiff for her business purpose. The plaintiff states that on 26/10/2024, the plaintiff herein was informed by one auto driver that the articles of the shop room are lying outside and upon hearing the same, the plaintiff immediately rushed to the spot and the plaintiff found the major stock of the shop room is lying outside and new stock was put in the shop room. The plaintiff states that upon seeing the condition of her stock, the plaintiff was in utter shock, and thereafter the plaintiff had informed her relatives who all came to the spot, and the plaintiff thereafter went to the police station Aberdeen, and the defendant herein was called in the police station, and the defendant agreed that the defendant had opened the lock and removed the articles from the shop room. that the plaintiff state that a plaintiff thereafter made a written complaint to the police station and FIR under this was chalked out against the defendant hearing. Now, your lordship may kindly consider this is just a minute. One thing I want to show. Date is same. 2510, 2510. I have
Yes.
stated 2510. This particular thing has happened. He says 2510, I have given the shop room to him. Back, handed over the possession. Your lordship, is it believable that 2510 voluntarily I will give the shop room to him and 20 possession is going from me, which is the basic thing. Suppose, assuming for argument's sake also, I had certain demands, I wanted some money, something of that kind. Why I will leave possession? Your lordship, even a layman knows if a possession is there, I am protected. If possession is there, I am gone. Nobody will do that. 26th October, I am lodging a complaint stating the entire facts in the complaint that how things have been done. And police authorities being satisfied with what actually has happened has lodged the FIR. Not only that, your lordship, I may say from that particular date till today, one police person is sitting there. Even today also police person is sitting there because all materials are lying outside.
Till now.
Till now, even now, if your lordship goes, your lordship will find one police person is sitting there. A commissioner can be appointed to see that if my learned friend disputes this thing. Even now, police person is there. Because they also know, your lordship, that these things have happened actually. I have been forcibly evicted, not evicted, I can say. It is a kind of partial eviction.
Your articles are there.
Inside, my half of my articles are still inside the shop room. And major portion is there outside. It's outside, lying outside. Lordship, it's very surprising that on 2510, I will vacate the premises by keeping half of my materials outside the premises, and next day I will lodge a complaint. Who can believe this? Story should be believable. And what story he has here, that is to be seen. One single sentence, 2510, I voluntarily vacated. Where is my 13 lakhs? In the agreement, security deposits 13 lakh was there. Which tenant will vacate the premises without receiving the security deposit back? I don't think that in the history any tenant would have vacated the premises without receiving at least the security deposit. Nowadays, your lordship knows that how the tenant used to demand money from the landlord to vacate. And this particular person will leave his security deposit also and will vacate. Something should be believable. My entire business, your lordship, at stake. I'm unable to run my business. She is running a tailoring shop there, earning her livelihood on the basis of running the tailoring shop. And she is now on road. All her materials, your lordship knows tailoring business, how it runs. The customers, they are every day, your lordship, they are coming to the house of the plaintiff and they are asking money back. And it's very difficult because she has purchased materials with that money and she is unable to run the business. So, your lordship,
Yes.
Sequence, if your lordship would see that on 23rd October, notice was issued. This is the original of the notice. Because these things
Where
were
is
there,
that,
part of
sir?
the record. But your lordship, it has not been annexed in the revision. This notice was issued 151.
V. Ravi. Who is V. Ravi? Landlord.
Landlord. V. Ravi is the landlord. Because we were anticipating that he's going to forcibly evict us. So notice has been issued.
Ah. So your client has invested 34 lakh rupees inside the shop.
Yes, Your Lordship, because materials have to be purchased. It's a tailoring shop by taking loan. Not what she doesn't have anything. She has borrowed loan, and from loan she has invested this much amount of money.
Not for purchasing of material, for decoration of
Yes,
room,
yes, Your Lordship, because certain things are to be done.
ceiling, electrical work.
Yes, yes. Because their room was given to us. So she has to furnish the room. For the purpose of furnishing the room, all these things were required.
No, so whether she had taken permission of landlord,
Yes, yes, Your Lordship. At that time, there was no dispute. Agreement, it is there. Just a minute.
how the 34 lakh would be accommodated?
Your Lordship.
How the use money of 34
Loan was borrowed from bank. It was borrowed from bank. Loan was there. Your Lordship, just 1 minute, I'll show you that thing. Yes.
loan amount was 10 lakh rupees.
This I can establish, Your Lordship, because I have borrowed loan from here, there, bank, everywhere in order to establish this thing. So this particular thing, Your Lordship,
No,
it's not that I am claiming that amount.
but that shop was on rent.
Yes, Your Lordship. It was in
So,
2019.
without any assurance of landlord, where and how you accommodate
I can
that
give
amount?
the details. I can give the details.
Not detail. The rent amount is only 16,300.
15,500. Security deposit was 13 lakhs.
13 lakh.
13 lakh also is there in 34 lakhs.
So you have to accommodate 34 lakh rupees from rent. Shop room is not yours.
No, Your Lordship, because
You are on rent.
for the purpose of business, I have to purchase many things. I have to fix
Today or
certain things.
tomorrow you have to leave.
Yes, Your Lordship. But there was an understanding between the landlord and the tenant that on the basis of that understanding, I have invested. And just a minute.
Okay. Yes.
Kindly come to agreement. Kindly come to agreement. Your Lordship will get the answer.
Yeah.
Page number 73. Page number 73, clause 10. Kindly see.
Okay.
The tenant should not make any structural alteration into or upon demand without previous
These
consent.
are the general conditions.
So main thing I cannot do, but Your Lordship, so far as furnishing is concerned, AC is there, many other things are there. For that purpose, some investment is required to be done. And Your Lordship, if I have a claim upon the landlord with regard to that amount, then those issues can be looked into at this stage. This stage, Your Lordship, it's a case, it's a little.
Out of curiosity,
Your Lordship. Now,
it will not affect you. Yes.
now, Your Lordship, the point is, Your Lordship, that's what I was telling about the sequence. This is 23rd notice was issued, 25th. That's what I am submitting, Your Lordship. What prompted the tenant to vacate the premises on 25th without even demanding the security deposit? Your Lordship, some story should be there in the written objection. Something that 13 lakhs was not paid. He has written was not paid. Now, Your Lordship, kindly see the situation. Rent agreement is accepted. Rent agreement is accepted. Yes, there is a rent agreement because his whole case is upon the period mentioned in the rent agreement. So rent agreement is accepted. One part of the rent agreement he will accept, other part he will not accept. Where 13 lakh is written, he says, I have not received it. This goes to show, Your Lordship, that the story of the landlord is unbelievable. Now, two courts, concurrent order is passed. This is a concurrent finding of the court. Prima facie, it's a case of forcible eviction. Now, exercising the revisional jurisdiction, that concurrent finding of both the courts can be reversed, Your Lordship. without there being any materials. I can understand there may be if there is certain things which the court finds that there is a perversity. Documents do not reveal all these things, but the learned court below, they have taken into consideration many things which are not based upon documents or which are not placed before the learned court below.
Yes.
I can understand, but this is not that type of case. No, Your Lordship, that's what I was stating. The other side has said that I filed the application for a direction upon the defendant to unlock the premises and to allow me to continue my business afterwards, after filing the suit. This is also an incorrect submission because along with the suit, I filed two applications. One under Order 39, Rule 1 and 2, not to create third-party interest, and one under Section 151, directing up the defendant to unlock this 151 application has not been annexed in the civil division. This is the 150. And kindly see the date of that application. And even in the order sheet, I have got the entire order sheet of the learned court below. This is reflected.
Yes.
This is the order sheet. About 151, it is reflected.
Dated
2810, 2810, the day when the suit was filed. Same day. This is the entire order sheet, Your Lordship. Of the, if it is there, entire.
Where is the
Yes, Your Lordship. First, page number. It is after 111.
28th day.
Yes, 28/10/2024. Kindly see the down. Learned advocate for the plaintiff files another application under 39 Rule 1 and 2 for and also filed an application under 151 CPC. Now, what happened, Your Lordship, on that day?
Yes.
What happened actually? The court said that this cannot be under 151. You have to file under Order 39 Rule 1 and 2 only, because there was some issues relating to the provision. Then it was not pressed, and subsequently the application was filed. A combined application was filed under Order 39 Rule 1 and 2. This is the actual story. My saying is that, Your Lordship, this particular thing, when we see the sequence, it is very clear. Now, even if suppose something is not so clear, it would be a hyper technicality, nothing more than that. Technical things. So, Your Lordship, this is it's a case, Your Lordship, where mandatory injunction should be granted. Kindly see the situation, Your Lordship, when prima facie both the courts have come to a finding that high-handedness landlord has forcibly locked the premises. Whether am I not entitled to get it opened and run my business? And this, Your Lordship, rent control regulation 2023 has also come, but Your Lordship, the authorities have not been appointed, because there the rent authority not function. Rent authority is not there, rent controller is not there, rent tribunal is not there. Nothing is there. Even assuming for argument's sake, it has come into force, then also rent agreement is of 2019, not 2023. So retrospective operation cannot be. No, Your Lordship, I am relying upon the judgments. I am placing the judgment. Your Lordship, the first judgment I will be placing, Division Bench of the Calcutta High Court, Indian Cable Company Limited. This, Your Lordship, it's up to the point, a tenant, and it is, I can say, Your Lordship, the situation is more worse than my situation. He has prayed for recovery of possession.
Recovery?
Yes, even then the court...
At least you have partial possession.
Your Lordship, here the tenant has claimed recovery of possession, and it was argued by the other side that how can he ask for an interlocutory order for recovery of possession when main prayer is also for recovery of possession. Law is settled. By way of ad interim relief, you can't get the main relief. That position of law is settled. But the court has said you have to look into the facts of each case. You cannot apply it like that. You have to see whether when the tenant was evicted. Now, your lordship, just I will place Indian Cable Company Limited, Sumitra Chakrabarti, Division Bench, Calcutta. Your lordship, I am not reading the entire thing. I
Yes,
will be reading the relevant paragraph only.
yes.
I have carefully considered the rival contentions put forward before us. Before I proceed to consider plaintiff's claim for injunction by of restoration on its merit, I must clear the two grounds on which, according to the learned subordinate judge, the plaintiff's prayer must fail in law. In my view, the learned judge clearly overlooked the provision of Order 2, Rule 2 in taking, this is the version of the other side. What the rule is. Yes. Just- In my view, the learned judge clearly overlooked the provision of Order 2, Rule 2 in taking the view that the present suit filed by the plaintiff company will be barred under such a provision only because the earlier suit filed by the plaintiff company, being titled suit number, this is still pending. What this rule requires is that every suit shall include the whole of the claim arising from one and the same cause of action, and not that every suit shall include every claim or every cause of action which the plaintiff may have against the defendant. The plaint in the title suit of this is to be found at page number this. It was based upon cause of action which arose. Now, in those paragraphs of the plaintiff, it was clearly pleaded the plaintiff had been in quiet and peaceful possession of the property until March this, when the defendant started abusing and harassing the plaintiff's men and agents in the matter of getting access to the pursued property. As a matter of fact, the factum of dispossession was not known to the plaintiff until April 2, 1982, when for the first time the defendant disclosed the setback in the affidavit in opposition. That was a simple suit for injunction valued at rupees 50, while the present suit is based on a different cause of, namely the dispossession itself, which arose on 24, means this is a case of exactly dispossession. Dispossession has already taken place and then the suit was filed. Now, I'm placing the So I'm not reading the entire thing, Your Worship, so I have to search the concerned paragraph so that it will be clear.
So we come day after tomorrow.
Your Worship, I'll continue.
Okay, Rafa. 12. 12 crore. Yes. Yes. Item number 3. Who is in item number 3? Not today. Item number 3.
Appearing for the petition.
Who is for the?
My lord, is the civil division, my lord.
Yes.
Challenging the order of the MS trial court, my lord. In this case, my lord, what happened at the factual is that the plaintiff has filed a suit for recovery of possession and title and interest, my lord. Thereafter,
Who is for the other side?
the other side is not
Notice.
No notice, my lord. My lord,
Come after sir.
my lord, there is some extreme emergency, my lord. For that, I am paying for extreme. What happened?
Pray for where is the application?
My lord, what happened?
No kind is there. ST application.
No, it is there in my prayer. It is there.
Come after service.
My lord, kindly appreciate, my lord.
No.
My lord, let me place the
Yes, my lord. Let me allow the place the case, my lord.
In absence of other side, how can I?
My lord, that is the very fact that has been happened before the court below, my lord.
When did you file this? On 9th of
My
the,
lord, my lord, it is a civil division, my lord. After admitting it, then only the notice can be issued. My lord, what happened in this case, my lord, that the Lenna trial court, the suit was dismissed for default, my lord. And after dismissal for default, my lord, there was a stay that was vacated, my lord.
what
And
was the
for
suit for?
My lord,
What was the suit for?
suit for title and interest, my lord, for possession and title, right title and interest, my lord.
Hmm.
Thereafter, the suit was dismissed for default and the stay order was vacated, my lord. And for restoration of the suit, the one order 9 rule 9 application was filed by the plaintiffs below before the trial court, my lord. And with the order 9 rule 9 application, the plaintiff has filed another application under section 151, my lord, for recall of the order, my lord. Recall of the order of the restoration, dismissed for default, my lord. That was allowed, my lord, without hearing opportunity of hearing to me, my lord.
Yes.
The now notice was served, no application was serviced upon me. The order was allowed, and the order of recall was allowed, my lord. The application under section 151 was allowed without giving opportunity of hearing to me, my lord.
So you
The-
became aggrieved
My lord,
by that order.
my lord, the order 9 rule 9 sub
And you want similar order from
my
where?
lord, it is civil
Without
route, my lord.
servicery notice.
My lord, this is civil route, my lord. After admitting it,
It may be, but you come after service.
My lord, kindly appreciate, my lord. My lord, the trial court has
Come
not
after
even
service.
followed the law, my lord. The
Come
order
after
9 rule 9.
service.
My lord, kindly appreciate, my lord, the order 9 rule 9 subclause 2, we say that
I
no
will
order
appreciate.
passed.
I will appreciate you come after service.
My lord, this is civil
No,
rule, my lord. After admitting only this notice can be issued, my lord. Because the right to audience was not given in before the court. The audio order was not at all meant.
I am giving you direction to come after service.
My lord, till date when the trial court's order may be statement. Till that time.
Why? What order is against you?
My lord, the trial court has recalled the order of restoration, my lord. Dismissed for default, my lord.
Recall.
My lord.
Then suit restate.
My lord, when the order
Then
and
what-
line
what
application
problem
was
you have?
pending, before when the order and line application was pending, in that order and application, 115 application was filed. Without reviving of the order and application was allowed, the 115 application was allowed, and the order of dismissal was
No,
revived.
so what emergency is there?
My lord, because the that order which was dismissed for default, in which the stay order was vacated, and by the action of the trial court,
No. After restoration of
I am saying that it
every
cannot
order
done.
will be restored accordingly.
My lord, it is not a suit, my lord. I am telling appreciate, it is not a suit. The suit was dismissed for default. The order and line application was filed for restoration of the dismissal order, and with the dismissal of restoration application, 152 application was filed. That was allowed without hearing me, my lord. For that application, I am saying, my lord, I am serve the notice upon the other side, my lord. Till
You
such
come
time,
after service of notice.
I
Take down.
such time in the application that order will
Take
be
down,
stayed,
take
my
down.
lord. My lord, till such time that order may be stayed, my lord.
Which order?
Order dated 18/11/2024, my lord. My lord, may come to the last page, my
Where
lord.
is the said order?
It is there in the last page, which was not paginated. The last second page, my lord.
An application under order 9, rule 9 of the. Original suit number TS 206 of 2024.
My lord.
What is in the suit?
It is there, my lord. I attached the claim, my lord. It is at page number 26, my lord.
But the said order of the mention was vacated for not taking a step. By the you was?
I am referred below. My lord.
No, in which judicial case you was?
I'm not served them for with the copy. That was the plaintiff, my lord.
You are a no. You are dependent there.
My lord. The
S. Praveen. You are S. Praveen.
my lord, my lord. The judicial case filed by the plaintiff, my lord, after dismissal of order.
Yes, this petition has been allowed.
My lord, without opportunity of hearing to me, my lord. My lord, kindly appreciate, my lord, the order 9.
Then what you want?
My lord, I am agreed by that order, my lord, without giving opportunity of hearing, my lord, the order 9, if, my lord, kindly appreciate, my lord, the suit is not in existence, my lord. How can this court can pass an order when the suit is not in existence, my lord? The suit is itself dismissed for default when there is no suit and the restoration application is pending. The trial court has passed an order.
Suit was dismissed for default.
My lord, my lord,
Thereafter one application was made.
my lord. Thereafter, application for restoration was filed, and with that application, one application was 115 application was filed, my lord, with the restoration application.
It requires hearing in presence of both sides.
My lord, till such time, my lord, the operation of the trial court operation order may state, my lord.
So there is no such direction.
My lord.
What direction is
My
there?
lord, the order was considered. Let the order of vacating injunction in original suit numbers also be recalled.
No.
My lord.
Not required. Take down.
My lord, kindly appreciate
Landed
the
advocate for the
very fact, my lord.
petitioner. Just a minute. Please let me pass order. Landed advocate for petitioner
My lord, in
is
that
present.
it might be fixed day after tomorrow, my lord. I will fix service tomorrow, my lord.
I am passing order. Don't interfere.
Sorry.
Landed advocate for the petitioner is present. He challenged the impugned order dated 18th November 2024, whereby order for vacating injunction in original suit being number title suit number 206 of 2024 was recorded and editing order of injunction was restored in its original form and injunction was extended till 26 December 2024. Let this petition appear under the heading of contested application. Petitioner is directed to serve notice on respondent and file affidavit of service within 3 weeks. Let this matter appear before the next circuit bench.
My lord, the very purpose of filing this question, my lord.
Yes.
Let's thank for the petitioner.
Yeah.
Let it be not today. That's the issue.
Not today.
My lord, I am for the respondent, my lord.
Yes. Who is for the petitioner?
Any kind of appears on behalf of the petitioner. My lord, today I filed my wakalatnama, my lord, so I pray let the matter be fixed in next circuit.
On the prayer of learned advocate from both sides, let this matter appear before the next. Hello, you are only interested to extension of a year. Seven, item number 7.
I'm for the petitioner, madam.
Your
Yeah.
Lordship, in this matter, this is Kavita Das is appearing for respondent, Your Lordship. I pray for not to take Your Lordship.
There is a
Not-
direction upon them to file the reply.
Where is the reply?
Yeah, affidavit they have to file.
He is simply praying for not to. do.
Not to Your Lordship.
Let this matter appear
Petition
tomorrow.
was passed in the month of September 25.
This matter will appear tomorrow,
When? 7 and 8.
7 and
7 and 8.
Nine, my lord, we are hearing for the respondent matter.
Lordship, let this matter be fixed tomorrow, Your Lordship. I pray for the petition, let this matter be fixed tomorrow, Your Lordship.
Not today.
Obliged.
One more thing, sir. 10, my lord,
Hmm.
Ms. Nag appears for the Ruma Bose. This has become infructuous, I think. Division bench has passed order.
Yes, but the single judge order is kept in abeyance for 3 months. So it should go
You know,
after 3
no,
months.
in any event, my lord has heard the matter as part of division bench, so my lord,
It should go to the
NH.
yes, my lord, connected appeal. No, this is Ruma Bose.
demolition.
Demolition matter. My lord,
Lordship, the division bench has held that the order of the single bench has to kept in abeyance for 3 months.
And
So-
appellate.
Yes,
Yes.
this has to be shifted in March circuit. That's what I'm submitting.
let it go out.
Let it go out of the list.
Let it
but
go
in
out
abeyance.
of the list.
That is better.
On the joint prayer of learned.
No, my lord, not joined.
Let this matter go.
It has to be joined there, sir. I will make my.
No, prayer was genuine.
Yes, that's what it has to be joined.
Let
there.
it go out of the list.
Because
my lord.
otherwise I
Okay,
will be
go.
missing for the hearing of the matter. He has to say that it has been kept in abeyance.
Yes.
Other matters are released except the matter of Mr. Bean for it. He's sitting for it. Other matters can be-
Mr.
Why,
Jaipal,
why are you in a hurry? Please, sir.
Mr. Jaipal chased away my books. Now at least I can bring them back.
After facing your matter, everything should be released. What is this matter?
My lord would recall your lordship had asked me to come back with an affidavit of service. Drugs
Yes.
and Cosmetics Act.
Yes, yes.
Allegation is for defect in manufacture. I informed your lordship it is defect in storage.
Yes.
Your lordship had.
Where is
asked me
affidavit
to-
for service?
I filed it, my lord. The affidavit of service is there. It has been served upon.
Oh,
the
who is
unit
for the Union of India? Where is
of- I
the,
don't
Mr.
understand, they are
Tulsi?
not appearing.
Sir? You are generally represent Union of India in this court. And in this matter, none of this
The procedure is, my lord, we are.
sub notice immediately. Hand notice.
We have served on the Central Drug Control.
No, I will pass order.
My lord,
I will
Madam,
pass
may
order
I
and
explain
instruct him to appear on behalf of the.
Well,
in the meantime.
I will
my
take
lord,
the instructions.
Two things are there. Let my development take the instructions. Two things. One, my lord, I was praying for the stay for petitioners number 2, 3, and 4.
Will appear day after tomorrow.
And then some difficulty, my lord, I told your lordship, I will not be there for next week.
When are you returning? By Friday?
It appear on Monday, my lord.
Okay.
With a copy of the,
Yes, sir, I will give
with
it.
the copy.
Despite service of notice, none appears on behalf of the Union of India is not represented. Mr. Tulsi Lal usually represent Union of India in court is requested to represent respondent number only one thing. Respondent number 1, Union of India in the revisional application being CRR number 33 of 2023. Learned advocate for the petitioner is directed to serve a copy of revisional application along with connected application immediately to learned advocate for Union of India. Let this matter appear on Monday.
Your lordship, permit me to take the prayer for review on Monday at the top.
That will be.
If it comes at the top, my lord, I'll have a chance of at least, because as your lordship recalls from the first day of the circuit, this matter I'm praying to the state.
On that day, everything was new for me.
Understood. But my lord,
Now
your
at
lordship-
least
Your
I
lordship
get-
was keen that I should finish the service, my lord, I have done that.
Yes.
Then your lordship had desired.
that's why I passed direction today. So that,
Application also I've taken out, service I've done, everything I've completed. my lord. That is why I'm saying only with regard to the accused 2, 3 and 4. Other accused trial will proceeding will go on. It is a complaint case. So they will appear to the summons. I'm only
Yes.
talking about these 3 persons.
Okay, yes, call the list.
Yes, but I appear for the applicants, but my lord. Very short question of law. It can be heard and decided.
State is here. Yes, what is this matter, sir?
My lord, the question of point of law only, the violation of section, the mandate of section 195 CRP code,
195,
195
sanction. Sanction,
CRP code.
yes, CRPC. In respect of
In
sanction,
respect,
yes,
the offence alleged and the FIR registered, investigated and charge sheeted, that includes section 188 IBC. And there is
Yeah.
a special
what is the impugned order? Cognizance has
My
been
lord,
taken.
impugned order is at page 18, my lord. 18.
1-8. Case recording. Petition praying for stop of the proceeding. Record. Petition praying for stop of the proceeding. Permitted from the side of the. Yes. Then what irregularity in this order, sir?
My lord, the petition before the learned trial court was filed for stopping the proceedings and to discharge.
Yeah, trial,
And
learned trial court has rightly passed
My lord,
this order.
my lord, may I-
He has
just-
no jurisdiction authority to stop the proceeding.
my lord, he has the jurisdiction to, has ample power to stop the proceeding. If it is found that if the case is proceeding basically on illegal tracks, while in
These are
violation
the
of the,
tribal matter, no? These are the matter relating to facts. And let it
My lord,
decide
my
before
lord,
the
the
time.
FIR, it is a violation of the protocol of COVID-19. and the FIR is registered under section 188 IPC, beside other sections. And the cognizance is backed in the eye of law. As per section 195 provisions, the very cognizance is backed. If the very
How
cognizance is
can you
backed,
say?
pardon,
How can you say?
but
Whether you have any evidence?
my lord, the law says it is the section
Mere
195.
oral submission is not sufficient.
I refer to the law, my lord, section 195 A1 of any offence punishable in section 132 to 188 of the Indian Penal Code. And the rest is except on the complaint in writing of the public servant
Yes.
concerned.
Where you service a public servant?
Public servant is a district magistrate DM. He had to file a complaint before the court for the violation of section 188
Against?
against the accused persons.
Who were the accused persons?
Accused persons are that two accused persons are there, my lord.
Yeah.
One is Abdul Hakim and the second is Omar Farooq.
Yes.
So in view of this mandate of the law, if the trial proceeds, despite the fact that it is the DM has not come forward to file a complaint, FIR was
DM may
registered.
empower someone, na?
My lord,
DM may empower, authorize someone to.
there is nothing on record. Even that person who is authorized,
Those are the tribal issues.
my lord, even that
cannot
person who is
be
authorized,
Decided.
it is not there. He has to come before the court and file a complaint
Yes.
case. Excellent. Barring that, the court cannot take cognizance on the basis of the charge sheet. The very registration of FIR is wrong.
Where is the written complaint?
My lord,
Where is the written complaint upon which FIR was started? Whereas
my lord, the FIR is page 12.
not available in record. FIR is, these are the formal FIR
Formal FIR.
initiated upon the written complaint. Where is the written complaint?
No written complaint.
Then,
Yes.
then how formal FIR on suo moto?
My lord, but a written complaint is there.
Yeah.
It has not been annexed with the application. There is a written complaint of one Rajesh Ram. On the basis of written complaint, the formal FIR was it.
So you have to file everything, na?
My lord, that's what I'm,
Without,
the very first thing, my lord, I submitted that the LCR may be called for because the copy of the FIR and the charge sheet, it is hardly legible. My lord may face difficulty. Because what was supplied to me, I could not do better than that. If the LCR is called for, my lord, the entire records will be before my lord.
yes, PP Sahab, have you anything to say?
My lord, in addition to this, my lord, I have a judgment of the coordinate bench on the very same issues. Very same issue, already decided. Violation of protocol of the COVID-19. The coordinate bench has already decided the issue. The Honorable Justice Bibash attended day in the CRR 35 of 2022. The entire proceeding was struck down. My case is very much covered within the ambit of the judgment already delivered by this Honorable Court. It's a misuse of the process of law if the trial continues. page 4, second paragraph is very much relevant, my lord.
Yes, yes, I am there.
After careful scrutiny of the entire record, including report in final form, I find that the entire allegation against the accused, including the petitioner, is revolved around the violation of.
What is the allegation against you? Where
Your
is the written
allegation against me
complaint?
that
Without written complaint, how can I assess
allegation,
what
my lord,
allegations are leveled against you?
there was an order of quarantine, one of the family members. And during that period of quarantine, the allegation is that I was found moving in the village. That was the violation of the order passed by the district magistrate.
There is no.
It's very much clear from the order judgment of the honorable judge passed in the CRR, my lord, that this kid
Do
cannot.
you have your diary?
That's so what happened was, may I submit this?
Yeah, yeah.
During Corona period, that is COVID-19, there was a notification, Government of India. There was some circular, nobody come out, nobody touch with the persons. What happened, this lady accused, she came from Maine. Thereafter, she was found COVID positive.
No, she is not an accused.
Found positive. Notice was affixed in the house of that person, two accused person. Thereafter, they violated. They taken a pickup van, vehicle, and going somewhere, then stopped by some persons, recognized persons, notified person by the deputy commissioner, that you cannot move because quarantine notice have been affixed in your house, you cannot come or you cannot go out of the house. So they did not listen, some altercation taken place, matter have been reported to the concerned PS by the Rajasthan. FIR has been registered under section 188 IPC as well as 269, 270 of IPC. 269 regarding the spread of diseases and 270 says. As per section 195, charge sheet has been filed. The petition has been filed by the trial court. Trial court has rejected that petition. That why not cognizance taken? Cognizance was taken, matter is fixed for trial. 195 bar, that is, kindly come to the 195 section, CRPC. Section 190. May I take that?
Yes.
Prosecution for contempt of lawful authority of a public servant, for offense against public justice and for offences relating to documents given in evidence. Then no court shall take cognizance of A1 of any offence punishment under section 172 to 188, both inclusive. See here, what is the, kindly see the situation and nature of the offence was? And is evidence inspector. So this 195 is not applicable at all. Second part 269 and 270 of IPC lordship. Because they come out from the house. Violation.
So why 195 is not applicable? Prosecution for contempt of lawful authority of the public service. So there is allegation that accused has violated the direction of public authority.
Lordship.
District magistrate, DM.
Then the next one kindly see, and public justice and for offences relating to documents given in evidence, then there is a bar under section 195 CRPC.
It is all or, not and.
And it is written, kindly see.
And.
So where is the bar? If it was or, the question of addressing in relation to the evidence, that is order or any notification, then there is a bar for proceeding taking cognizance under section 188 IPC.
Yes.
Can you see the second part also? 269, 270 of IPC lordship. How that can be forget? So cognizance rightly taken, charge sheet have been filed. This put a question of fact can be taken in the trial.
That point was raised in the earlier case, and that has been denied by the honorable court, that it cannot stand independently.
Yes, I will go through with you.
My lord, my lord, my lord.
Actually, I could not gone through that judgment. That of Honorable High Court. I will take from my mistake.
Fortunately or unfortunately, I myself appeared in that case on behalf of the state.
Now you are appearing on behalf of the accused. So, I am passing order.
Actually, Lordship, they already submit, but regarding that judgment, I couldn't go through.
So,
I will go through the record, that judgment, Lordship, if possible, Lordship.
So, tomorrow-
Lordship.
tomorrow,
If necessary, I just reply of that time.
yeah,
I have forgotten.
tomorrow. Not today. Oh,
Next page will not have any matter.
आज से जहाँ छूटा है कल से वहीं से शुरू होगा 13 से शुरू होगा नहीं तो पीछे वाला पीछे ही रह जा रहा है कभी नहीं चांस पा रहा है
Lordship, can I mention something regarding item number 20?